Can I start, Ayush?
Shikanji,
Ayush?
just one more.
Yeah, sure.
We are live.
Yeah. Good evening. Good evening, everyone. We National Reconstruction. Good evening, everyone. We National Reconstruction Society. We invited today Dr. Vikas Bhati to give us a speech about Semiconductor Integrated Layout Design Act, maximizing and enabling law for national economic development. And this should be and Dr. Vikas Bhati, a senior professor in legal studies at RML NLU Lucknow. And he is PhD and he had many honors and also one of the major person behind patent law. And thus, we are here to discuss about this semiconductor law and TRIPS regulation and others, and thus how it will be helping in our national development and economic growth will be discussed further. And to sir,
You are mute, sir.
now to sir. Yeah.
Am I audible?
Yes, sir. You're audible.
Thank you for such a generous introduction. We are gathered today to discuss the Semiconductor IC Layout Designs Act and how this law, which is a enabling law, should be utilized to its maximum for the economic benefit of our country. Friends, we all are aware that these chips, IC chips, are the beating heart of any electronic device you can think of today. Be it your calculator, be it your washing machine, be it your smartwatch, car engine, right to a spacecraft, your computers, satellites, they all depend on these chips. Now, the layout of that chip is also protectable as a form of intellectual property. But to that end, this Act of 2000 has been enacted. To give you background to this and why I've chosen this topic, all of you must have heard about Taiwan, which acquires a center place in designing of these chips. Taiwan's economy is, in one way, entirely dependent upon their capability to design these new chips and sell it all over the world. And the crisis we encountered during COVID pandemic, wherein these chips could not reach India. And it has a huge impact on variety of industries. And it was largely felt upon the automobile industry because we do not have access to those chips. Things could not be imported in India. And that brought the entire economy in various sectors to a standstill. So therefore, this ability to have your own semiconductor industry and not being entirely dependent upon a foreign country for the purpose of utilizing those chips emphasize the need of this act. For our purposes, we can classify the law as enabling law And therefore, opposite to that would be a disabling law. An enabling law is that species of the law which allows a particular sector to develop. A disabling law or a regulatory law, on the other hand, would stop certain things from happening in a particular sector. IP laws are basically enabling laws. So when we grant an IPR right in a layout design, we therefore incentivize another person to make that new design, new layout of an integrated circuit. This had been provided as a subject matter of intellectual property by this Act. And when this Act incentivizes the manufacturers or the makers of those designs, it contributes, therefore, to a particular sector which has implications over a variety of sectors. So my point is that utilization of this law acquires a center place in order to ensure economic development of the country itself, because it helps into so many sectors. And that reduces the dependency of India onto the foreign countries. Now, the importance of Taiwan for China, for US, and for all over the world is because of that industry, right? So therefore, the government now has proposed to incentivize indigenous designing and manufacturing of the chips in India. That is a purpose of it, to reduce dependency upon others. Now the question before us is this really happening? If this would have been really happening, then we can see the evidence of that in the amount of registrations of those layout designs before the Semiconductor Registry, which is the official office for grant of this IP right. Now we see that this act was being enacted in the year 2000, and we are in 2025 now. So almost a period of 25 years, quarter of a century. But in that quarter of a century, you would be surprised to know that only 2 registrations have happened. And those 2 are also the Navratnas, or you can say government companies. So no private player is playing an active role in designing of those chips. Another evidence to that is that there has not been a single case law, no single dispute wherein an IP right has been claimed. So lack of or absence of registration, absence of case law, places before us an evidence of this activity not happening here. One may argue as a countermeasure that this act basically provides a right to exclude others for a period of 10 years. All right. And 10 years for this fast moving industry where new and original layout designs would come on a regular basis. And this act also further says that registration is not required for the first 2 years of commercial exploitation of that layout design. So one can say that basically within that 2-year period, maximum benefit has been taken out of that layout design by commercially exploiting it. And post 2 years, maybe the design itself has become obsolete or has become old, or you can say something which is less efficient. So therefore, companies or the makers or designers do not have an incentive to register at the first place. Rather, they would just simply commercially exploit it. And that commercial life is shorter. So therefore, they are not going for registration. There can be some truth in it, right? But still, only 2 registrations shows that activity of designing of those layout designs is not happening here. Okay. Now, maybe that is also for the reason that short span or short economic life of the design itself, or the act itself is not considered to be helpful by the designers or the makers or the manufacturers of those integrated circuits. That is, a burden has been placed upon them to substantially prove that their layout design fulfills all the substantive criteria for the registration under this act. That is, it must be new, it must be original, it must be distinctive, amongst others. So instead of going through the burden of establishing those substantive requirements, that is, this particular subject matter qualifies, is itself a task. Okay. So one may, therefore, instead of going through the hustle and bustle of the registration process itself, would simply commercially exploit it, and wherein, when they are aware that there is a short span of economic life of this design, they could exploit it freely within the period of 2 years, and if found advantageous that this can continue to have a economic life beyond that period of 2 years, they would go for registration. But all in all, we cannot say that this 2-year window that has been provided by the Act itself is the reason why registration is not happening. There might be some truth in it, but absence of registration, absence of the finding of any court, therefore leaves much of the space open for interpretation. So that's one way of putting it. Now, enabling law helps a particular sector to develop in a particular manner. So, for example, IP filings in case of patents is continually increasing because there isn't enough an economic incentive which gives the patentee a right for a period of 20 years to exclude others. So there is a rise in the patent applications, but that is not occurring here. If both the laws are of the same species, if both the laws are enabling laws, then that would have been observed here as well. But and it isn't there. Okay. So my point is that this enabling law has not been utilized to its maximum extent. Now, what can happen if we do not do that? We can take a learning from the US itself. US was manufacturing things, but they needed chips in order to manufacture those. So they shifted the market of production of those electronic chips to a foreign destination, in this case, Taiwan. When the industry has entirely moved to a foreign territory, the US industry itself became dependent upon the Taiwanese chips. Okay. Now they had came to the realization that this was a mistake that they had committed at that point of time, wherein they are transferring manufacturing and designing to a foreign country and buying it from them, wherein they could have done it themselves. Shows or exposed the dependency of the US industry itself over Taiwan. The same can be argued about us. If we do not do it, we are dependent upon a foreign country in order to do it for us. That approach needed to be changed. And the echoes of that started occurring in the US industry itself. And when the effect of that approach was felt during the COVID era, Indians are also incentivizing manufacturing, indigenous manufacturing of these chips. So there are various initiatives like Make in India, etc., which would reduce the dependency of our industry, variety of sectors, over a foreign country. And that's the reason why I'm saying so. Coming to a general understanding of the law itself, as to why it has been protected as a separate species of intellectual property and has not been brought under the umbrella of patent law, or let's say design law, or under the copyright law. A separate law in itself has been made for this purpose. Patent law would not be a good law for it, because patent is a monopoly for 20 years. And the requirement of patentability are pretty high as far as the standard is concerned. So one has to show that their product is, their design is, new. They further had to prove that it is non-obvious. They further had to show its utility. So those barriers are not simply met by the chip itself. So that's too high a standard for enabling a chip to be a patentable subject matter. Coupled with the fact that it's a fast-moving industry, 20-year period is not required. And often it happens that they are dependent upon previous designs in order to come up with their new and original designs. So that level of dependency is there. So therefore, patent law would not be a good law. And that exclusion can be seen within the Patent Act Section 3 itself, which says topography of integrated circuit is not a patentable subject matter. So clear exclusion from that law. The reasons are these. Therefore, we have to look elsewhere. So one may argue that why not copyright law? Why we cannot consider the layout of the chip to be an artistic work? It's a form of an expression. Canvas of that expression is the semiconductor material on which this etching of wires would be made. So it would be made up of several layers, and on those several layers, artistic work in the form of the pattern of wires, conductors, etc., transistors would be etched on that canvas. So therefore, an artistic work, and can potentially be a subject matter of copyright law. But there's a difficulty here. Copyright law standards are too low a standard for an industrial property. Chip belongs to the category of an industrial property rather than an expression. Copyright law considers itself with the expressions of an idea. Right? They can have a separate industry in itself. Say, for example, cinefilm, cine industry is there. Musical works, music industry is there. Artistic work, art industry is there. Literary work, publishing industry is there. But essentially at the heart of it, what is copyrightable was the expression. And it is not equated. It is not considered equal to an industrial property. Secondly, the standards are pretty low. Copyright law says that it must have been fixed in one way, and there must be human authorship. And thirdly, most important requirement would be that it must be an original expression. Now here in original expression has two things to look into. The first is that it must be creator's own expression. That is the first part. To say it must be creator's own expression is to say that it must not have been copied from another source or another's work. But is that enough? No. There has to be a certain minimal level of creativity in that expression. So, okay, we can say that this layout design has not been copied. But is there a merit in this work? The standard of merit is minimal, right? Minimal creativity in the expression. And this minimal creativity, if we say that a chip layout design is an artistic work, that is artistic skill. So separate kind of intellectual effort is required for copyrightable subject matter. So if it's a poem, we can say there must be a literary skill present in that work, however small it might be. If it is an art, a painting, right, then there must be presence of a minimal artistic skill. So it's not demanding the same intellectual effort that would be required in order to design a layout of an integrated circuit. So therefore, copyright law shall not be able. Another problem with this is that copyright is being given for an extensive period, which as a general rule, if I say, that can be up to the extent of life of the author plus 60 years. And that's a very long duration. So if we grant artistic copyright to a layout design, we would be essentially making it a subject matter of copyrightable protection that would continue for life plus 60 years. That's too extensive a duration. And that is not required in order to incentivize someone from designing a layout chip. That's too long. That would be an economic life that travels beyond. That would be the life of the copyright that travels beyond what is required in order to maximize your economic returns as a measure for the investment you had made in the making of that layout design. So that's another issue. Third is, chip designs are basically compilations of staple forms. So it would involve wires in a straight line. So these are standards, right? A transistor would appear to be of a particular pattern. Stable forms are not considered to be copyrighted, right? So it can be squares, rectangles, lines. They by themselves are not copyrightable because they are believed to be free for all. That is, they must remain in the public domain. An alphabet by itself could not be made copyrightable because it's the staple, it's the basic thing which anyone needs in order to create a literary work. Likewise, a line, rectangle, squares, these are all staple forms which would be needed by everyone in order to design a layout. Therefore, copyright law is not good for that. Third thing is, we say that it's a layout design, so therefore Designs Act must apply. Can we say that? No, absolutely not. Design Act is an industrial property. Layout design is also an industrial property. But the functions of both these species are different. A design is intended to create a visual appeal. A design is not functional, right? Chips are functional things. and they are not intended to create a visual appeal in the eyes of the observer. For the simple reason, they are not visible to the consumer. They are inside the equipment itself in order to ensure the functioning of that instrument. So layout design is not intended to create a visual appeal, while a design is solely intended for that purpose. Thus, therefore, Design Act would not apply. Trademark, can that be applied? No, again, trademark is an indicator of the source. That is, when an average consumer would look at a product and there has to be some indication on it which informs the consumer about the source of that product, where it is coming from. So trademarks are indicator of source. Is a chip an indicator of source? No, it is not observable. It's not informing the consumers about the source of that chip. It's inside, right? So design itself cannot be a trademarkable subject matter, plus trademarks can be practically for perpetuity. Till that remains to be the subject matter, protectable, till that remains to be not a generic term or not a generic designation, till to the point that it has been utilized, continually utilized by someone as their trademark. So it can be, trademark can be 10 plus 10 plus 10 plus 10, it can be centuries, it can be 200 years, it can be 300 years. That is too long in life for the layout design. So the trademark law doesn't apply. So therefore, there was a need which was felt to provide for a separate kind of law, which came to us in the form of this act. How it happened? 1990, Washington Treaty came around, which was followed by the TRIPS Agreement. Now, TRIPS has adapted the Washington Treaty in itself. So now the international law which regulates layout design would be the TRIPS Agreement, and this TRIPS Agreement has informed the Indian law. And there was a transition period of 10 years which was given to us, being a developing country, that we had to make our domestic law in compliance with the TRIPS Agreement. So we had till 2005 to provide for those areas wherein no law existed. Integrated layout design has been separately prescribed as a protectable intellectual property. Therefore, TRIPS mandates member states to enact domestic law in line with the TRIPS Agreement. That is, that basic minimum shall be provided by the members by way of a domestic law. If not, then TRIPS is backed by a World Trade Organization, so therefore economic sanctions would follow. This is the reason this threat of economic sanctions forced the Indian government to adopt this law. But as I was previously mentioning, that this law has not been utilized to its maximum. So it was in one way a mandate upon us by the TRIPS, which is backed by World Trade Organization, to enact a domestic law which provides for protection to layout designs. Right? That's why this law. The second point that I would be making here is that what is the understanding about substantive requirements of the law? As I was previously mentioning, that globally there's a dearth of case law on those issues. We do not know actually which way a particular case would be decided, because there is no guidance which has came from courts by way of their decisions. However, certain observations can be made about that. Section 7 of the Act, if I quote it, provides for prohibition of registration. That is, it's not saying in positive terms that for registration of a layout design, these things must essentially be present. What it rather says is that if this is the situation, then such a layout design cannot be registered. So it's negative connotations. If we compare that with the patent law says that it must be a product or process which doesn't falls under section 3 or 4 of the Patent Act, which is new, which is non-obvious, and which is capable of industrial application, is patentable, is an invention which can be patented under the Patents Act. Herein, it's not in the same terms. Herein, it says that if it is so, it would not be registered. Okay. So what those prohibitions are? That it shall be original. If not original, not registrable. If it has been previously commercially exploited, not registrable. If it is not inherently distinctive, not registrable, and which is not inherently capable of being distinguishable from any other layout design, not registrable. So I would make an observation about this aspect of new and original, which is present in the section 7. New means absolutely new. New would be called, new is a relative term. That in relation to what? So newness is seen of a subject matter looking at what existed previously in time. The same thing had existed by way of publication or by way of use, that is already present in the public domain. It will not be considered to be new. So presence in the public domain can be shown by it being present in the market, is being sold in the market. If it is already being sold, it would not be considered to be new. Novelty is something which is a requirement of patent law, but an altered version of novelty is found here. The altered version is that it must not have been commercially exploited for more than a term of 2 years. So let's say I designed it today on 9th March 2025, then I would have a period of 2 years after this date of first commercial exploitation, to postpone the registration. And the layout design would still consider to not have been commercially exploited, that is not fall into the public domain, if a registration process is initiated within that period of 2 years. So this is an altered version of novelty, right? In patent law, it must be absolutely new, not being known by way of publication, not being known by way of use before the date of filing of complete specification, must not have been present in the public domain, must not be accessible to the public. Herein, it is accessible to the public is by it being commercially exploited in the market, but still it would remain new for that window of 2 years. Okay, so that's the difference in the novelty we see in the patent law and the novelty we see for the purpose of the layout design. The second is, if it is not original, then it can't be registered. This is to say that certain degree of originality must be present in that layout design. Now, does the original here means the same thing as originality under the copyright law? No. One aspect of that which is common to both the laws would be that it must be their own creation, that is not being copied from another layout design. In copyright law, we also say is that it must be creator's own expression. It must be author's own words, must not have been copied from another source. Likewise, the first component is common. But the second component in the copyright law is different from the component in the layout design. Copyright law would say that it must be sufficiently creative. That is to say, it must display a minimal level of creativity. But what kind of creativity are we speaking? So Indian courts in Eastern Book Company versus D.V. Modak says, Supreme Court of India, that this minimal level of creativity is to be found in the skill and judgment of the author. Now here in court is referring to what? What kind of skill? What kind of judgment? Right? That skill and judgment would be that which is required in order to make that expression. So in artistic work should display certain, however small it might be, but certain original skill and judgment in terms of artistic expression. This is not the case here. Herein the law says that it must be creator's own intellectual effort. So therein, creativity has a different meaning. Therein, creativity means skill and judgment of the author in order to make that expression. So it can be literary skill, it can be artistic skill, etc., etc. But herein, what law is asking for is that it must be creator's own design, plus it must involve a certain intellectual effort. So this is a higher standard. This is not equating the originalities. This component is not equal to the standard of originality, second component. Own intellectual effort is different from skill and judgment of the author. So what we say here is that the requirement of originality in this act, as per this law, is greater than, is a higher threshold as compared to the requirement of originality under the copyright law. But does it goes to the requirement of originality being equal to the requirement of novelty? No. If we read this A and B, section 7, subsection 1, requirement of novelty means under the patent law absolutely new. So herein, creators' own intellectual efforts shall not be equated with creators' novel intellectual effort. Neither it is mandating upon us that this is equal to the inventive step. That is, chip must, you cannot say that it must display inventiveness on the part of the designer of that chip. No. Originality being met with when you are able to show that it was creators' own intellectual efforts. So own design, not being copied from other source, plus own intellectual effort, that is, had been displaying a certain level of intellectual effort in making that design. So the requirement under this law is therefore somewhere between the requirement of patentability and the requirement of copyright law. So if we say that the requirement of patent is this is the highest threshold, possibly in case of any form of intellectual property. It must be absolutely new, it must be non-obvious, it must be useful, plus it must be an eligible subject matter. right? That is not required here. However, the threshold under this act doesn't goes to the level of copyright, which is too low a standard. So this requirements of this subject matter being protectable by the law is between the requirement of patentability on one end of the spectrum and requirement of copyrightability on the another hand of the spectrum. It's greater than copyright law, but it's lower than patentability requirements. Point 3 and 4 is not clear. What does the law means by inherent distinctiveness? And what does the law means by saying that it must be clearly distinguishable from existing layout designs? Distinctiveness is a concept which is there under the trademark law. That is, it must be distinctive about the source. Okay, that is to say, it must clearly answer the question about the source of the product. Rather than telling us what it is, it must tell us where it is coming from. We say that that trademark is distinctive, which distinguishes the goods of one from those of another. This capacity must be present in that mark. So apple for apples is not distinguishable, because such a usage is a generic usage, wherein the information is given about the product itself. So consumer would not look at the trademark as designation of its origin, that is to say where it is coming from, rather than answer to the question what it is. So we say that it lacks in distinctiveness. It lacks in that ability to distinguish one goods and services from another's goods and services. Does that mean the same thing here? Maybe. We do not know. However, it is unlikely to apply the same standard of trademark law to this act, because these are inherently different subject matters. So one way of looking at that would be to say that maybe the law here means that it is comprising of a different material. So it can be a particular kind of alloy which had been used in the wires, right? Which distinguishes. So that is one way of looking at it. Another way probably can be that it performs a different function altogether. So this is like a hunch. We say that it might mean this, or may also mean some another thing, but there is no case law on this. We do not know, right? So that absence of clarity is there, which can clearly inform the stakeholders as to what is required on their part in order to make it a eligible subject matter. All right. So I'll take 2-3 more minutes to speak something about the exceptions to this right. And that also would indicate to you that how it is different from other laws. I would talk about two things. One, reverse engineering, and another, independent creation. Section 18 provides for several other exceptions. One can be an innocent mistake. Another can be for the purpose of research, testing, etc., etc. It is allowed to do, right, despite the presence of a right. Amongst these, there are two other exceptions. One is reverse engineering. Reverse engineering would be that if we start with the product, so the starting material is the product itself. Herein, in this case, that would be the chip, the design of the chip. So we take the chip, pick it apart layer by layer. A chip is comprised of many layers. And on each layer, there's an etching of that pattern. So we separate it one by one and therefore discovers as to what the layout of this chip was, the design of the chip itself. Right? But while doing so, if not done for the purpose of research, but in order to make a chip for yourself, by way of reverse engineering, you are not allowed to copy the chip itself. But what you are allowed to do is that you can take apart that chip and make an original design for yourself. So it must not have been copied. It must not have been. It must involve creators' own intellectual efforts. So chip out of reverse engineering is protectable subject matter by itself, provided that it is shown that it is original as per section 7 of that. That is one thing. This defense of reverse engineering is not applicable to the patent law. You cannot simply take a medicine, put it to chemical analysis, and discover the composition of that medicine. One cannot do so. However, that's an absolute defense in trade secrecy law. That is, you can take a Coca-Cola bottle, put it to scientific observation, and discovers what the formula of Coca-Cola is. Right? So that is permissible under trade secret law. That is not permissible under the patent law. Right? But that is permissible to a certain extent. In trade secret, it's an absolute defense. In patent law, it's no defense at all. An altered version here in this act would be that reverse engineering is allowed, provided that you come up with an original layout design. That was my point. The second is the defense of independent creation. It's different from reverse engineering. You are not going backwards in time. You're not taking the chip and discovering what it is, what the design of this chip is. But rather, you are designing it from point 0 and reaching upon the same result. Independently creating an identical layout design is allowed. Okay. Now, independent creation is an absolute defense under the trade secrecy law. That is, you by yourself, by your own independent efforts, come up with a formula of Coca-Cola. Hello, Coca-Cola can't do anything. That is not allowed under the patent law. That is no defense at all. So one cannot say that they had made the composition of this medicine independently. That is, they are not copying. The starting material was not the product at hand, but rather they had independently developed it. Okay. So it's no defense under the patent law. It's an absolute defense under the trade secrecy law. Herein, it's also an absolute exception. So it's not asking from you, by way of independent creation, you can design an identical layout design. So it's not burdening that requirement of originality as is there under the defense of reverse engineering. So these were the major points for my discussion. I would invite the questions now.
Yeah, thank you for such an informative session, sir. My first question is, what are all with the implementation of this law, how Indian government can implement it effectively by providing certain tax incentives and other some required amendments with which it can help in Make in India and Atmanirbhar Bharat scheme, so that we can become one of the major destination for this silicon chip manufacturing. How can this law be more helpful for that?
This law is actually helpful. The thing is, the industry has not developed here.
Okay.
So by giving other incentives. This is an incentive in itself that you are operating an intellectual property right. So that gives you power for a limited duration that you can exclude others from copying it. So that's an incentive by itself.
Okay.
However, if we do not develop the ability to design the chip at the first place, who is going to take that incentive?
Yeah.
So that can be done by measures such as you were saying, that maybe you provide incentives in other forms. Say, for example, incentives in tax exemptions.
Yeah.
Capitalizing the industry, right? Other kind of relaxations that are permissible by law. So it would be a mixture of the economic policy, wherein companies would initiate the process of designing of the chip, and then this enabling law would come into picture to its maximum extent, right? So my point is, it's an incentive in itself. However, that incentive is not being relied upon because of the absence of the industry itself.
Yeah.
So
got it.
Reforms in other ways are therefore required.
Yeah. And now the next question is, how does Semiconductor Design Layout Act is compared to that of similar laws that are available in European Union, China, India, and USA, rest of the world? How it is helping them in progressing, while in our side it isn't much? That is the question.
See, Indian law is in line with the TRIPS.
Okay.
Now, TRIPS is an international agreement which prescribes a basic minimum. That is, this much is to be provided within your domestic law. So that basic minimum is being adapted by every member states within their domestic laws. So be it US, be it China, be it us, right? However, or be it Europe. However, differences can occur. That is, one can go TRIPS plus, right? That is more protection of the intellectual property, right? So law can be adapted, domestic law can be adapted, which is benefiting or which is easing up the grant of intellectual property. So one can go TRIPS plus. What is not allowed is to go TRIPS minus. So that basic minimum would be present in every national legislation. But over and above, what those countries can do is providing more IP friendly approach within the domestic law, that is going TRIPS plus. So that can be a point of difference between domestic laws of various other countries and India.
Yeah.
However, we have not gone TRIPS minus here. We have remained at the level of the TRIPS itself.
Okay. Yeah, I understand.
TRIPS would be trade-related aspects of intellectual property rights. So it's an international agreement.
Yeah. And one question: what are all the loopholes that, as of now, hinders the semiconductor industry growth in India? According to this act, actually, based on this act, this TRIPS regulation. Yeah.
I mean, I do not find the problem within the act itself, right? But is that practical utilization of this act happening or not? So there is one thing to put on record that there is a law. But if law has not been utilized by anyone, or the need had not been truly felt by anyone to utilize it, shows the lack of the industry itself, right?
Yeah.
So it's not the mistake of the law, is the policy approach which needs to be relooked at. That is, we need to develop the industry first.
And so one question. Yeah. And another question: what are all the things that can be done to encourage the silicon manufacturing ecosystem in India?
That would be, repetition of the same points I was making. That is,
Yeah.
you incentivize the industry itself, wherein the industry is encouraged to make those intellectual efforts in designing of the layout. So several
Yeah.
labor reforms, for example, or setting up of innovation labs, right? Innovation hubs within the institutions. Say, for example, IITs or others, leading institutions here, wherein researchers are allowed to use that potential. So you give them office space, you give them a lab to work in, you give them economic incentives, tax relaxations, etc., etc. And then there would be enough an incentive, because once they design, then the need would be felt to have it registered. Right? If registration is not happening, that is, that economic activity is not happening. Right?
Yes.
If the economic activity was there in reality, then we would have seen far greater number of registrations and not merely two in this period of 25 years.
Yes. Yeah. And thank you very much, sir. Now the question session is over, and I thank you very much for your time and enlightening us with the law based on that is this chip manufacturing and the regulations on trips and other things and comparative laws in other countries and how India can use them for the larger good, for the development of nation and for the economic activity. I thank you very much, sir, for your time.
Thank you so
That,
much for your
that's
kind
fine.
words.
Yeah.
Okay, we will
Yeah.
meet again sometime.
Yeah, sure, sir. We'll meet again. Yeah.
So can you switch on your cameras? We can have a photograph or something.
Yeah, sure. Ayush? Ayush? Yeah. He's asking, sir is asking for a group photo. He's asking us to switch on, asking all of us to switch
Those
on
who
our
can,
cam.
those who
Yeah,
can.
those of us can. Yeah.
Please switch on your camera if you are not facing any problem. Hello.
Okay, you take ours. Wait, just for.
Yeah, that's good.
Just for me.
Okay, Ayush.
Okay, thank you very much.
Yeah.
See you some other time. Okay.
Yeah.
Shall I
Thank
end the
you.
meeting? All right.